complaint that was received on December 19.
A verified complaint for impeachment by a member of the House or by any citizen upon a resolution or endorsement by any member thereof
In behalf of the
shall
House,
be filed with the office of the Secretary General and immediately referred to the Speaker. Bakit hindi po nasunod ang tuntunin na ito, Mr. Speaker? Kailan po ni-refer ng Secretary General sa opisina ng Speaker yung impeachment complaint dated December 2, 2024? Kailan po ni-refer ng Office of the Secretary General yung impeachment complaint na i-file noong December 4? Wala po silang sagot. Kailan po ni-refer ng Office of the Secretary General yung impeachment complaint that was received on December 19? Wala po silang sinasabi. Kapag titingnan po natin ang sagot ng Solicitor General in behalf of the House of Representatives, ang sabi po nila, the Secretary General diligently referred simultaneously all the impeachment complaints to the office of the Speaker on February 5, 2025. Immediately po ba yun, Mr. Speaker? December 2, December 4, December 19, at isinama po yung February 5, all of them were simultaneously referred to the office of the Speaker on February 5. 2 buwan po ang kanyang ginugol para lang i-refer sa office of the Speaker. Ano po ang immediate doon? Wala po. Wala po silang sinunod. Wala silang ni-refer at ni-refer nga po delayed. Nung ma-refer po, ang sabi po ng Solicitor General, the 4 impeachment complaints were included in the order of business doon po sa session number 36. You will note, Mr. Speaker, hindi po niya ibinigay bilang annex yung order of business in section number 36. Ang kanya pong ipinakita ay yung journal number 36. Bakit po? Sapagkat hindi totoo na yung 4 na impeachment complaints were included in the order of business. Mr. President, I have a copy of the order of business, session number 36. And I will deposit a copy to the office of the Senate Secretary for everyone to see and examine for themselves kung talagang in-include nila sa order of business. Wala po. Saan po nila in-include? Doon sa journal. Iba po yung journal sa order of business. Alam po niyo kung bakit lang nalagay sa journal, Mr. Speaker? Idinagdag po nila as additional reference of business. That is not the requirement of the Constitution. Pwede po ba nating makita yung slide, ano sinasabi po ng Constitution? A verified complaint for impeachment may be filed by the member of the House, blah, blah, blah. Ang sinasabi po rito, hindi ba yun? Hindi po yun. Sorry po. Nakalagay po, in-include sa 10th session day. Yun po yung section number 36. Hindi po totoo yun. Ilang violations na po? Kanina po, in-archive po yung tatlong violations. Hindi po ni-refer sa Committee on Justice. Pangatlong violation. 6 na po. Ngayon sinasabi po, in-include po sa order of business. Hindi rin po. 3 violations na naman. 9 na po. At sabi po nila, yung session 36 is the 10th session. Hindi po. Bilangin po natin yung December 2. That was the date when the first complaint was filed, endorsed, and received by the Office of the Secretary General. December 2 is session number 26. Mr. President, bilangin po ninyo yung session number 26 up to session 36 na sinasabi ng Solicitor General. Yun po ang 11th session. That was not the 10th session. Ang 11th session is session number 35. Just for the record, Mr. Speaker. So ilang violation na po yan? Balikan po ninyo yung Rule 2 na nandyan po sa slide, Mr. Speaker. Ano po yung mode of initiating impeachment? Ganito po ang sinasabi ng rule of the House of Representatives. Impeachment shall be initiated by the filing and subsequent referral to Committee of Justice. Ito po yung Sereno versus, Francisco versus House of Representatives. Verified complaint for impeachment filed by any member of the House of Representatives, i-refer po sa Committee on Justice. Verified complaint filed by any citizen upon a resolution endorsement by any member thereof, i-refer po sa Committee on Justice. A verified complaint or resolution impeachment filed by at least 1/3 of all members of the House, i-refer din po sa Committee on Justice. Bakit po ang ginawa nila nung makakuha sila ng higit sa 1/3, dali-dali po nilang tinransmit sa Senate? Ang pagkakakala po nila, Mr. Speaker, sapagat ang pinagbatayan po nila ay yung Rule 4 na kung saan in Section 14 sinasabi po endorsement of the complaint resolution to the Senate. Ang sinasabi lamang naman po noon, Sir President, ay yung pamamaraan kung paano po i-endorse yung impeachment complaint that was signed by 1/3 or even more members of the House of Representatives. Hindi naman po sinasabi doon na hindi na sa i-refer sa Committee on Justice. Bakit po nakalagay dito sa rule? Kailangan i-refer din siya sa Committee on Justice, but they never did. Mr. Speaker, Mr. President. So ilang violations na po ito? You cannot use Section 14 in isolation of Section 2. Hindi po pwede yun. Binigyan po ba ng discretion, Mr. President? Was the House given the discretion to select, to withhold and select from among the 4 impeachment complaints, which will be the one to be transmitted in the Senate in derogation of the 1-year ban rule? Wala po silang discretion. Kung sila po mismo ay hindi sumusunod sa tuntunin, bakit po ngayon ay napakarami pong nagsasalita na parang akala mo ay ang Supreme Court pa ang nagkasala, ang nagkamali. Samantalang ito po, napakasimple po ng tuntunin, hindi kailanman sinunod. Even the 10th session day na sinasabi nila, 11th session day nung ilagay po nila sa order of business, sabi nila. They never included them in the order of business. Wala po. Nasa akin po yung kopya. Ano ba po ang pagkakamali? Mr. President, ipakita po natin yung last page ng impeachment complaint. Pakita po sa slide. Ayan po, Mr. President. Subscribed and verified before me. Sabi po ng Secretary General. Tambay ko, rin. Subscribed and verified before me on this blank day of February 2025. Wala pa pong date. Ito po ba ang verification, Mr. President? Hindi po. Ang verification po ay nakasaad po sa mismong tuntunin ng House of Representatives. Balikan po natin ang Section 3. Ano po ang sinasabi? Section 3, Paragraph 2. An impeachment complaint is verified by an affidavit that the complainant has read the complaint and that the allegations therein are true and correct of his personal knowledge or based on authentic records. At the very least, yun ang dapat na ilagay po. Nakalagay po ba sa verification dito? Ng Secretary General ng House of Representatives? Wala. Ito po'y parang jurat lang sa isang affidavit. Sinasabi lamang po dito, kilala niya yung nagsipirma sa isang dokumento. Na ang dokumento ay naglalaman ng 32 pages. This is not the verification required under the rules of impeachment by the House of Representatives. Ang totoo po, kung balikan po natin ang Section 14, nandyan po sa slide. Isinulat na po sa tuntunin kung ano po ang dapat kopyahin nila para magkaroon ng tunay na verification. Hindi pa po nila kinopya, Mr. President. Ito po yung contents ng verification na dapat sana yun ang nilagay nila sa complaint. We, sabi po rito, after being sworn in accordance with law, depose and state that we are the complainants in the above entitled complaint or resolution of impeachment, that we have caused the said complaint resolution to be prepared and have read the contents thereof, and that the allegations therein are true of our own knowledge and belief on the basis of our own reading and appreciation of documents and other records pertinent thereto. Kukopyahin na lang, Mr. President. Hindi pa nakopya. Mr. President, alam mo po, nung ako'y grade 4, yung teacher po namin, binigyan po kami ng isang short quiz. I-drawing ninyo kanya yung Bicol region. Siguro po 1963 yun, Mr. President. Yung Masbate, hindi pa kasali sa Bicol region. O hindi, kabisado ko naman po sapagkat mahilig po ako sa social studies, Mr. President. Meron pong dalawang nangungopya sa akin. Yung isa nasa likod, yung nasa kaliwa ko. Yung nasa likod po, nakopya niya pong tunay yung aking drawing. Pinagalitan siya pero ipinasa po sapagkat nakopya niya po yung aking drawing. Yung isa po, nangopya na nga, hindi pa niya nakopya. Ang kinopya po, Masbate. O wala po. Hindi po siya nakapasa. Ano pong ibig ko sabihin dito? Kukopyahin na lang. Alam po ninyo sa mga litigation lawyers, practicing lawyers worth their salt. Wala ka lang certification of non-forum shopping, i-dismiss ka ng Supreme Court. Maliwanag po yun. Hindi subscribe yung complaint mo, dismiss ka kagad. Mahigpit po ngayon eh. Ito po, this is an impeachment complaint. You are removing the second highest official of government. Yun lamang pong verification. Sablay na po. Ano pong nakalagay dito? Section 3, paragraph 3. An impeachment complaint required to be verified which contains a verification based on information and belief or upon knowledge or information and belief or lacks proper verification, katulad po nito ngayon, shall be treated as an unsigned impeachment complaint. So pwede pong tratuhin pala ngayon sapagkat wala pong verification. It may be treated as unsigned impeachment complaint. Paano kayo? Bakit magsasalita po ng napakarami? Alam po ninyo kung, Sir President, kumbaga po sa nagluto ng sinaing, pasensya na po kayo kung kinakailangan ako po'y gagawa ng pagkahalin tulad, ano? Ang impeachment complaint po ay parang sinaing na niluto ng House of Representatives. Hilaw po eh. Hilaw na hilaw. Ano po yung hilaw sa Bicolano, Mr. President? Hilaw din po yan. Sa Bisaya, hilaw din po. Sa Kapampangan, magadto, Mr. President. Sa Waray po, matagutod. Sa Ilonggo po, lagdos. Sa Ilocano, marakusol. Sana po tama ang aking pagkaka-pronounce. Ang dami pong nagsasalita, Mr. President. Doon lang po sa House of Representatives, isa pong bagong pasok doon, ngunit patagal na pong nagserbisyo sa ating bansa. Naging senadora, naging Secretary of Justice, naging chairman ng Human Rights Commission. Alam po ba kung ano sinabi niya sa isang panayam? Ito po, nakuha ko. Harap-harapan na tayong niloloko. Kakaibang korte ito. Sana sa palengke na lang final ang impeachment case. At least doon, may nagtitinda ng totoo. Sana po, magtinda po siya ng matagutod na kanin diyan sa Samar. Baka may bibili kaya. Pwede kaya siyang pumunta diyan sa Pampanga po para magbenta ng magadto na kanin. Kung may bibili, baka sakali. Pumunta kaya sa Panay para magbenta ng lagdos na kanin? Wala po siguro, Mr. President. Baka ngayon dagang dingding, hindi pa patusin. Huwag pong ganun. Ang dami na pong nagsipagsalita. Samantalang hindi po nila nakita. Ang dami, kayo po nagsimula ng mali. Hindi naman po sinasabi ng Korte Suprema na kailanman ay huwag kayong mag-impeach, huwag na kayong mag-file. Ayusin nyo lang po eh. Yun lamang po ang gustong mangyari dito. Ayusin nyo. You want to impeach the Vice President, do it in the right way. Hindi naman po tinignan ng merito eh. Ang sinasabi yung proseso, hindi po nyo sinunod eh. Sinasabi na nga, walang impeachment complaint bukod sa isa. Laban sa isang opisyal sa loob ng isang akalain mo namang 4 po kagad ang ipinay. Pagkatapos yung 4, i-consider mo na isa. Hindi naman po yata tama yun, Mr. President. Mr. President, gusto ko pong basahin isang parte ng official statement of the Integrated Bar of the Philippines and the Supreme Court's decision in Duterte versus House of Representatives, August 1, 2025. And I quote, "Disagreement with the court's reasoning is neither unwelcome nor unexpected. Dissent is not foreign to a democracy. It is essential to its survival. But to incite public repudiation of its authority, or even just to call for its outright defiance, erodes the very foundation of the legal order. Such actions disturb the equilibrium of powers and imperil the integrity of our democratic institutions, especially when appropriate legal remedies remain available within the framework of our constitutional system. If every adverse ruling becomes an invitation to disobey, the law ceases to be a constraint on power and becomes its casualty. The Constitution does not require agreement. It demands adherence." Ang sinasabi po ng mga ibang kasama natin, magpapile pa naman ng motion for reconsideration. Bakit hindi natin hintayin? As I said, Mr. President, if you are a practicing lawyer worth your salt, you are confronted with the unanimous decision of the Supreme Court. In a firm voice, it says this is unconstitutional, void ab initio, violative of due process, and the Senate never acquired jurisdiction over this. And it is immediately executed. Parang sinasabi niya sa'yo, wala ka ng room mag-file niyan. Is anyone expecting that even one soul of the members of the Supreme Court will reverse himself? We cannot defend our action, Mr. President, on the fortunes of litigation. Naalala ko pa nga po doon sa kaso ng Francisco versus House of Representatives. The former Chief Justice Renato Puno, in his separate concurring opinion, naalala ko po ang sabi niya, with the possibility of 2 impeachment complaints reaching the Senate, the good Chief Justice said that the Senate, in the exercise of its primary jurisdiction, can decide the question of whether or not the 1-year bar rule has been violated or not. The Senate can even decide if on its face the impeachment complaint has no legal basis. At ang sabi pa po niya doon, Francisco versus House of Representatives, sabi pa niya roon if the Senate finds that the 1-year bar rule is violated or that the impeachment complaint has no legs to stand on, that will be the end of the entire controversy. He was saying that let's give all the remedies available to the House and the Senate because of their primary jurisdiction. But when the case is ripe for judicial determination, it was the view of the former Chief Justice that the Supreme Court at that time, and only at that time, when it can speak with great moral authority, in order to compel the loyalty, the respect, and the obedience of our people. Mr. President, when the Supreme Court negates the actions of a co-equal branch of government, it does not assert its superiority. Instead, it upholds the supremacy and the dominance of the fundamental law of the land, the Constitution. And so the Supreme Court has already spoken. The last arbiter of law, it says the complaint is unconstitutional, is void ab initio, is violative of due process. The Senate never acquired jurisdiction over this. It is immediately executory. On that note, Mr. President, I respectfully move that the impeachment complaint be dismissed. I so move, Mr. President.
Majority Floor Leader.
Mr. President, before, Mr. President, we act on the motion of the distinguished gentleman from the great province of Tarlac and Rizal. Mr. President, the motion is not among the privileged motions listed under our Rule 32, Section 90 of our rules. Therefore, Mr. President, it is debatable and may be subject to clarificatory questions. Nonetheless, Mr. President, our movant, Senator Marcoleta, has the floor, and Mr. President, subject to his consent and with his magnanimity, clarificatory questions on the motion may be entertained. In fact, Mr. President, we have some members of the Senate who wanted to interpolate with the permission, Mr. President, of the...
What is the pleasure of Senator Soto, our distinguished Minority Floor Leader?
Thank you, Mr. President. If the distinguished gentleman from Tarlac favor me with a few questions, I will be gladly accepting this favor. And if the Senate President will allow me, after a few questions, I will make my own manifestation to that effect.
The gentleman may proceed. Should Senator Marcoleta so allow it?
Yes, Mr. President.
Thank you, Your Honor. Thank you very much, Mr. President. Thank you. So, listening to the privileged speech of the distinguished gentleman from Tarlac, the basis of your motion to dismiss is the Supreme Court's decision, which is now pending appeal by virtue of the MR, or the motion for reconsideration filed last Monday by the House of Representatives. Is it not, Your Honor?
The question is whether is it...
Yes, your
subject
basis
to a-
for your motion to dismiss is based on the Supreme Court decision that the so-called impeachment is unconstitutional, based on their decision.
Yes, Mr. President, Your Honor. That's very, very clear and categorical.
Correct. The Supreme Court decision, Mr. President, although immediately executory, is not yet final. Thus, appealable. Ngayon, naka-appeal na. Marami nagtatanong, kung naka-appeal na, ba't tayo nagmamadali? I-dismiss ito sa atin. So may I ask the gentleman, what will happen if we prematurely dismiss the case and the Supreme Court subsequently grants the MR and reverses its own decision?
The question, Mr. President, is speculative.
Yes. May I have a speculative answer, Mr. President?
We cannot speculate. We can only guess, second guess, because on the basis of our experience as a practicing lawyer, Mr. President, ito pong ganitong klaseng desisyon, talaga pong wala na pong kaduda-duda na kahit po mag-file pa tayo ng motion for reconsideration. We are hoping against hope. It is as if we are wishing for the moon. Palagay nyo po, palagay nyo lang po merong isa na nag-reverse. Hindi rin po ma-overturn. Kasi po ang kailangan po ninyo ay 8 ang mag-reverse. Sa inaakala po ba ninyo, meron kayong makukuhang 8 na pumirma doon sa unanimous decision na babalik ta rin po nila yung kanyang sarili. Kaya, napakahirap pong mag-speculate, Mr. President.
I will accept the answer of the gentleman, but I have done my research, Mr. President. And to remind everyone, the reversal of the Supreme Court's own decision is not impossible, even in landmark cases. In the case of Labogal, Dilaan Tribal Association Incorporated versus Victor Ramos, GR number 127882, December 1st, 2004, questioning the constitutionality of Republic Act 7942 or the mining law, the Philippine mining law. The Supreme Court granted the MR, reversing and setting aside its earlier ruling. And also, Mr. President, just a few days ago, the Supreme Court reversed its own ruling on the definition of a stockholder. This is the case of Lily Lopez versus Lolito Lopez with GR numbers 25497-957-58. So, may kasabihan po tayo, ang tumatakbo ng matulin, kung matinik ay malalim. Kaya dapat siguro pag-isipan muna natin kung tama ba na bago magdesisyon ang Supreme Court, basta ibasura na natin ang kaso na ito.
Unang-una po, Mr. President, gusto kong malaman, yung po bang mga kasong sinabi nyo, unanimous decisions po ba lahat?
I am not sure about that. But one thing I can say is that if there is a mistake, unanimous decision could become a unanimous mistake.
Wala pa pong nangyaring gano'n, Mr. President. At saka po tayo, pag nananakbo, ako po ay nakasapatos at saka sa kalsada kaya hindi po ako matitinik.
Well, Mr. President, there's always a first time. Regardless of whether it's unanimous or not, unanimous decision does not bar an appeal or a reversal, Mr. President. That is one thing for sure. Now, secondly, where is the ball, Mr. President? Or meaning the impeachment case itself? Is it in the Senate or in the impeachment court? Didn't the impeachment court throw it back, remand it, returned to the House of Representatives? So what are we dismissing in the Senate kung wala sa atin ang kaso? Can we continue hearing the case and dismissing it without the impeachment case in our hands? Can we throw the ball out when the ball is not in our possession? Siguro naman dapat magkaroon tayo ng tinatawag nating sense of proper sequencing of moves. Nasaan po ba yung impeachment case?
Mr. President, kanina po sa aking clarificatory statement, ang sabi ko nga po, yung ginawa pong initial proceedings ng 19th Congress Senate, yun po ay nangyari sa panahon po ng 19th Congress at lahat po yun ay naisantabi lahat sapagkat natapos nga po ang termino ng 19th Congress on June 30, 2024. Kaya po natin sinasabi, Mr. President, na dinidismiss na po natin ngayon sapagkat tayo po ang nasa lugar na sinasabihan ng Korte Suprema nung sabihin niyang ito ay immediately executory. Sino pong mag-i-execute nun? Hindi naman po i-execute yun ng House of Representatives. Maliwanag naman po na tayo lamang ang tinakdaan ng kataas-taasang hukuman na gumawa ng paraan para isantabi na po ang usaping ito sapagkat napagtibay nga nila na ito'y unconstitutional, void ab initio, at wala na po tayong jurisdiction para dito.
Thank you, Mr. President. Your Honor, thank you. But as I said earlier, that because it is immediate and executory does not mean it's not appealable. Now, to continue, Mr. President, I hope you don't mind. I will be posing a question, but then I will be doing a manifestation based on this question that I will be posing. So I'm certain that the gentleman from Tarlac has read the 97 pages ruling of the Supreme Court to come up with this motion. So the question is, must we agree on the statement of the decision of the Supreme Court on page 3, page 56, as basis that the 1-year ban has set in? With that question, allow me to proceed with my manifestation with your permission, Mr. President. For the benefit of our colleagues, my colleagues, the last paragraph of page 3 states that, quote, since the 19th Congress terminated, the 3 impeachment complaints became enacted upon, end of quote. Again, this was reiterated in page 56, second paragraph of Roman numeral 5. It says, quote, the House of Representatives, however, was unable to act on the first 3 impeachment complaints because of the adjournment of the 19th Congress. To continue, for constitutional purposes, the first 3 complaints were effectively dismissed. In both instances, Mr. President, the Supreme Court was referring to the February 5, 2025 adjournment. But they have, erroneously believed that the said adjournment is the same adjournment with a sine die adjournment that ends a Congress. It is not. February 5 did not terminate the 19th Congress as stated in the decision. The sine die adjournment of the 19th Congress was on June 13, 2025, wherein the last session day was last June 11. Mr. President, and for the information of the public, there is a world of difference between adjournment versus adjournment sine die. Now, sa atin, pag nag-adjourn tayo for the Christmas break, nag-adjourn for the Easter break, nag-adjourn for the election period, nothing dies. The treaties, bills, resolutions, anything filed continues. It does not, it is never archived. Well, perhaps the lawyers of the ponentes did not realize that, or they were not familiar with the rules of Congress. As I said, this is a world of difference. Now, this is a transcendental case. Ang laking constitutional issue. Wala man lang oral arguments, or at the very least, a consultation with some members of Congress or members of the bar na nakakaintindi ng rules ng Congress regarding the procedure. In that matter alone, Mr. President, kasabihan ninyo mga lawyer, falsus omnibus, falsus unos, falsus omnibus. Mistake in one, mistake in all. In that manner, they wouldn't have decided based on their unfamiliarity with the legislative process. May mali agad eh. Pati ba legislative rules natin gusto nila palitan? Ganun ba yun? maybe not everyone may appreciate the importance of the legislative calendar of Congress. But us, it is a big deal. That's why I'm stressing this point. Concurrent joint resolution pa nga when we approve this calendar, only to be misinterpreted and used erroneously in this case. Nag-adjourn daw yung 19th Congress. Kaya na-archive lahat. Now, may kinopya lang, kopya, mali pa. Sabi nga kanina ng ating distinguished gentleman from Tarlac, hilaw. Hilaw yung complaint. Hilaw din yung decision. In addition to this factual error, Mr. President, it can be seen in the website of the House of Representatives that the 3 impeachment complaints were referred to the Committee on Rules and were consigned to the archives on February 6, not February 5, as claimed in page 78 of the decision. Nag-housekeeping lang ang House, kaya in-archive, hindi to end the Congress. This archiving were not the results of the ending of the 19th Congress, but because of the fact that the 4th complaint were already filed and transmitted to the Senate. Dito pa lang, Mr. President, pilit na patunayan na barred ang 4th complaint. Kapag ayaw, may dahilan. Kapag gusto, may paraan. Now, to continue, Mr. President, and this is very much related. The Supreme Court, by the way, if it is wrong, if the complaint done by the House of Representatives was wrong, we cannot correct a wrong with another wrong. The Supreme Court essentially amended the Constitution by removing the 3rd mode of filing of impeachment complaint. This 3rd and speedy mode was enshrined there for a reason. In times that there is an urgent need to impeach a person who is influential and powerful and may use his position to evade the law, the 3rd mode, which is the fastest way, was provided in the Constitution. Why don't you ask the authors of this provision in the Constitution? Constitutionalists or CONCON delegates Munsod, Ascuna, Sarmiento. So, Mr. President, continuing, if the Supreme Court is now changing the meaning of initiating, then at the very least, please apply it prospectively. However, they are applying this new ruling retroactively, which is a violation of the doctrine of operative facts. Kung ganito kanilang kagustuhan, at susundin natin basta-basta, apektado din dito yung nakaraang impeachment, the impeachment proceedings. In the words of retired Supreme Court Senior Justice Antonio Carpio, I quote, "The said Supreme Court decision practically voided the impeachment proceedings against former President Joseph Estrada and former Chief Justice Renato Corona." Pag gusto talaga, may paraan. Pag ayaw, may dahilan. Pero wag naman sana pati sa mga ganitong bagay that will ultimately affect future impeachment and legislative rules and proceedings. Sa atin yun eh. I've read that the basis for the retroactive application of the new definitions because The Senate now has not acquired jurisdiction yet. Eh, Mr. President, ano tawag natin doon sa nag-constitute kayo as an impeachment court? Nag-robe pa kayo. You even sent out summons. Ano yun? June 9, the Senate President took his oath. June 10, nag-convene ang impeachment court. Niremand to the House of Representatives. Tapos yung issue of the summons to the defense. Eh, ano po tawag doon? Hindi nag-convene? Baka hindi nabalitaan ng Supreme Court na hindi nag-convene. Kaya naisabi nila yan. So, now, just an observation. I will try to shorten this, Mr. President. Just an observation, Mr. President. Well, not only myself, but several lawyers mentioned this to me, including my godson, former Senate President Aquilino Pimentel III. Naguluhan sila sa pagkakasulat ng desisyon. It is incoherent and some parts are off topic, sabi nila. Para bang pinagtagpi-tagpi. Basahin niyo mabuti. Uli, ang daming gagaling ng mga abogado rito. Basahin niyo. It even quoted the entire Article 11 of the Constitution not only once, but twice. It seems there were two ponentes. Parang dalawa author dito. Well, that is there in my observations. Just an observation. So, Mr. President, the personalities in this present impeachment case is of no moment to me. The Vice President is a friend of mine. The former President, President Duterte, has been my friend since 1988. Everybody knows that. What I'm pointing out is the danger of outright dismissing the impeachment proceedings by virtue of a decision that is not yet final and still pending appeal. Justice Leoded himself said, Mr. President, I quote, "The Supreme Court is not perfect. Citizens and academics certainly have the right to call attention to the fallibility of the courts." Tama po yun. There is no perfect institution. Even Supreme Court ka, pwede mag-commit ng grave abuse of discretion or culpable violation of the Constitution. A case decided unanimously does not mean that it is infallible. For all we know, it is a unanimous mistake. That again can be corrected by setting aside and reversing prior pronouncements. Again, they have filed, the HRP has the Office of the Solicitor General has filed the MR last Monday. So, in this regard, we shall wait for the resolution of the MR. Please, let us allow and give chance to the Supreme Court to rectify its decision, which contains clear and blatant errors. For their sake and for the sake of future proceedings, let us not dismiss forthwith. And in that light, considering the motion of the gentleman to motion to dismiss, I move to table the motion to dismiss. A motion to table has a higher precedence than a motion to dismiss. Thank you, Mr. President.
Mr. President, may I have a quick reaction to the manifestation of the gentleman?
The gentleman may do so if he so desires.
Mr. President, in the answer of the Solicitor General in behalf of the House of Representatives, there was already a categorical admission that the three initial complaints prior to the fourth one were dismissed because they were all archived. As I have said, archiving is not part of the rules of impeachment of the House of Representatives, but they just did it. Palusot lamang po yun, Mr. President. Paano mo i-archive nang hindi mo susundin yung tatlong steps na sinasabi ng sarili nilang tuntunin? These are not baby steps. These are constitutional steps. At kanina po ipinakita yung slides na yung inclusion in the 10th session day is constitutional. The referral to an appropriate committee is constitutional. There was no referral to any committee. Ang ginawa po nila, tinransmit nila sa Senate without requiring themselves to observe another provision of their own rules. This is to refer to the Justice Committee, where the Vice President might probably be given at least a modicum of right to defend themselves. That is what we call due process. Wala po eh. Inakala po nila na kapag may 1/3 na or more, ay pwede na nilang huwag gamitin yung Section 2 ng kanilang rules. Hindi po nakalagay yun eh. So hindi na po kailangan na i-distinguish pa natin yung adjournment and CND adjournment. Kasi inadmit na rin po na in-archive nila kahit na wala po sa tuntunin. Kanina sa manifestation, tinanong din po. Kung wala tayong jurisdiction, paano yung unang initial proceedings? Pwede po yung initial proceedings ninyo will be considered under the doctrine of operative facts. Hindi pa po na-declare na wala pang jurisdiction ang Senate at that time. Ngayon lang po nangyari. Kaya po yung ginawa ng Senate of the 19th Congress, tama pa rin po eh. Wala pa pong declaration noon. Kaya lang, ang kagaya po ng aking clarification na sinabi, all these initial proceedings conducted in the Senate of the 19th Congress were not officially transmitted to the 20th Congress where I myself belong, a Congress of different composition. So yun po ngayon, naharap tayo ngayon sa issue na talagang tayo lamang po ang gagawa because there is no other agency of government that will execute that decision of the Supreme Court. Only the Senate. So may I go back to the first question, to the original motion, Mr. President.
Mr. President, if I may.
Majority Floor Leader.
Thank you, Mr. President. With the indulgence of my colleagues, Mr. President, our Senate Minority Leader, Senator Soto, and first movant of the motion, Mr. President, Senator Marcoleta, may I respectfully appeal, Mr. President, of our, and remind, Mr. President, our colleagues of our concurrence during our caucus held last week that we will debate on this and talk about this and discuss this matter, Mr. President. But if the minority leader would continue to insist his motion, Mr. President, we have no other choice but to dispose with the motion of the minority leader, considering that it takes precedence, Mr. President, with the motion of Senator Marcoleta.
It is the understanding of the chair that during our all-member caucus, which the chair announced in plenary, that it was agreed unanimously by all the members that we will be discussing, debating, and acting on the Supreme Court decision on a date certain. And this was the date certain that was agreed upon in caucus. Maybe hear from the distinguished minority floor leader if there has been a change in that position given on that date when we had an all-member caucus.
Mr. President, I as a matter of fact, concur with what you said. But during that time when we discussed it, there was no MR filed. There was no motion for reconsideration filed by the House of Representatives or the Solicitor General. So it becomes a different, it develops into a different scenario now that there is a motion for reconsideration. Because again, my question was not clearly answered when I said, what happens if we move to dismiss as as Senate or as impeachment court? I think that is one of the questions that is going to be posed by another member of the Senate, and we wish that you could recognize them to continue debate on this matter before we decide. But again, my answer is that there was no motion for reconsideration when we agreed to decide on August 6 on the motion to dismiss. That's why my motion is not against the motion to dismiss, Mr. President. It is merely a motion to table the motion to dismiss, which you may be able to take up on the floor even tonight or tomorrow. A motion to table is alive always in parliamentary rules. And you may take it up anytime. Then we can take up the motion to dismiss after that, Mr. President. Thank you.
We note the intent of the distinguished minority floor leader, but the chair would therefore like to make some points known before we act on the motion.
Mr.
What is the
President,
pleasure of the majority floor leader?
Mr. President, upon conferment with the minority leader, Mr. President, he is amenable, Mr. President, for us to continue with the discussions and debate on this particular topic, Mr. President. And so, with that, Mr. President, may I move that we recognize the distinguished gentleman from Cavite, Senator Panfilo Ping Lacson, to ask his questions, Mr. President.
Well, first, the chair would like to thank the
Thank you,
magnanimity
Mr. President.
of the distinguished minority floor leader in order for us to be able to continue with the debates. The gentleman from Cavite, Senator Lacson, is recognized for his interjections with leave, of course, of the gentleman who has the floor, Senator Marcoleta. You may proceed, sir, if Senator Marcoleta so desires.
Thank you, Mr. President. This is not an interpellation. Rather, this is a manifestation to be followed by a parliamentary inquiry.
The gentleman may proceed then.
Mr. President, I've been diligently reading and reviewing the rules of the Senate since I've been out of this august chamber for 3 years. Nowhere in our rules can I find a provision on a motion to dismiss as submitted by the honorable gentleman from Tarlac. Neither is there a supplementary application of the rules of court to offer a space for such motion to dismiss, except perhaps in the committees performing their legislative inquiries in aid of legislation. Obviously, we are now assembled in plenary, not as an impeachment court, but as a legislative body, and I cannot relate to a motion in this plenary to an issue that involves a collective decision that falls solely and exclusively under the jurisdiction and authority of an impeachment court. Having said that, Mr. President, my parliamentary inquiry is addressed, of course, to the Senate President. Mr. President, how do we deal with the pending motion? I refer to the motion to dismiss. Shall we even take it up or deal with it? Kasi wala po sa rules natin. Paano wala tayo pong guidelines? Kasi wala po sa rules natin yung motion to dismiss. So anong guidelines ang susundin natin in addressing the motion to dismiss submitted by the Honorable Marcoleta? Assuming arguendo, Mr. President, that the motion is voted upon and adopted by this body, what if, Mr. President, the Supreme Court reverses itself when it rules on the MR filed by the House of Representatives through the Solgen? Shall we also backtrack and reverse ourselves in dismissing the impeachment case? I pose that question, Mr. President. Thank you.
Thank you, Senator Lacson. To respond, we were faced with this question, but the very people asking us to wait right now were the very same people who were telling us before to ignore the pendency of a case in the Supreme Court precisely regarding this impeachment complaint. They were egging the Senate, even if we were on recess, to precisely proceed with the trial in spite and despite the pendency of cases in the Supreme Court. And the chair, with an abundance of caution, same with the good senator right now, decided to afford the Supreme Court time during the recess to decide on the matter. And when they did not, the Senate, in accordance with its duty, convened the impeachment court when we resumed session. Given that we cannot conduct impeachment proceedings that have not yet begun yet during the recess. To answer the query with respect to motion to dismiss, this was actually done, although not via a motion to dismiss, but a motion to archive in relation to the impeachment complaints of then President Estrada and Ombudsman Gutierrez. In fact, in the case of Ombudsman Gutierrez, it was our distinguished minority floor leader himself, acting as majority leader, I believe, who moved that the case be archived, given the resignation of then Ombudsman Gutierrez for being moot. In the case of President Estrada, the case was likewise archived for being functus officio, given that EDSA DOS happened and a new president was sworn into office. Your Honor, I believe the chair believes that we will have different interpretations of the effect of the Supreme Court decision. But ultimately, as I discussed with the majority leader earlier, once a decision is made by the Senate and the period to seek a reconsideration of that decision put to a vote has expired, the next logical step would be to archive so that it will be made part of our records. It is the position of the chair, subject to the wisdom of the plenary, Your Honor, that given the Supreme Court decision that the Senate never acquired jurisdiction over it, that the proceedings and the articles of impeachment were null and void ab initio. Indeed, there might not even be anything to dismiss, and the procedure would be more properly to archive, similar to what we have done in the past, so that these proceedings will still be made part of the Senate's records. But we will cross that bridge once we put it to a vote, Mr. President.
I go
Your
back
Honor.
to my previous question, Mr. President. Anong gagawin natin sa motion to dismiss? How do we deal with it? We are in
Answer,
plenary
Mr.
as a legislative body. We're not an impeachment court. So yun ang tanong ko po, Mr. President. Yun ang essence ng aking parliamentary inquiry.
The predisposition of the chair is what I stated, but subject, of course, to the wisdom of plenary. Maybe here from Senator Marcoleta, with respect to his ideas, given that he is the proponent
Mr.
of the
President,
motion.
it is true that the motion to dismiss is not part of our rules. But it is part of our rules po yung pagiging suppletory application po ng rules of court. In the rules of court, yung korte po can motu proprio dismiss a case kung wala pong jurisdiction. And considering that the rules of court has become part of our rules, that's why I use the motion to dismiss. Pag wala pong jurisdiction, halimbawa, sa isang korte, collection case po ito, 5,000 pesos po yung pinahal niya, dinismiss po ng court kahit hindi pa sumagot yung kalaban, Mr. President, kasi ang jurisdiction po ng korte hanggang 3,000 lang. Ganun po ibig sabihin nun. Minsan po, wala pong, hindi po verified yung complaint, dinismiss. Sa motu proprio, talagang dinidismiss. Paano po kaya kung sinabihan pa nga na the Senate didn't acquire jurisdiction over the case? Mas lalo po sigurong dapat nating panindigan na talagang i-dismiss na po natin, Mr. President.
Senator Lacson is recognized.
Again, I refer to our rules, Mr. President. Wala rin po ako makitang suppletory application sa rules of the Senate pagdating sa plenaryo. Pwede pong gamitin ito sa mga committee hearings, inquiry in aid of legislation. But we are not there. We're here in plenary. Maski po basahin natin na 100 beses ang ating rules of the Senate, wala pong suppletory application sa ating rules. Thank you, Mr. President.
The point of Senator Lacson, insofar as that is concerned, is well taken. Senator Pangilinan.
Just on the point of
Is recognized.
suppletory, the rules of court being suppletory. Mr. President, the rules that are suppletory presupposes that there are no rules of the Senate or the Senate impeachment court. In other words, in the absence of a standing rule, or provision of either our Senate rules or the Senate impeachment court rules, then we refer to the rules of court as suppletory to our rules. But in this case, the Senate impeachment court has a specific rule, resolution number 39. Upon presentation of the articles to the Senate shall specify the date and time for the consideration of such articles. Unless the Senate provides otherwise, it shall continue in session from day to day until final judgment shall be rendered, and so much longer as may in its judgment be necessary. In other words, as an impeachment court, of course, not as a Senate in plenary, but even that is now being debated because this representation believes the sole power to try and decide impeachment cases is the impeachment court and not the Senate in plenary.
Mr. President,
Majority Floor Leader.
Mr. President, next to interpolate, Mr. President, on the list of this representation is the distinguished gentleman from Taguig and Pateros, no other than Senator Alan Peter Cayetano. I move that he be recognized, Mr. President.
If I may, Mr. President, with the indulgence of the good gentleman from Taguig and Pateros, yung akin po ay
The lady may proceed.
susog doon kay Senator Lacson ng mga punto.
But, Your Honor,
It's
the
not an
chair-
interpellation yet, Mr. President. A follow-up point to the point of Senator Lacson. If the SP
lady may
and
proceed.
the gentleman. Thank you, Mr. President, and with the indulgence, as I said, of the good gentleman from Taguig and Pateros, nabanggit na rin po, Mr. President, pareho ni na Senator Lacson at Senator Pangilinan, yung usapin ng tayo ba, Senate or Senate impeachment court ba? So this is a point of inquiry, actually, a brief point of inquiry, Mr. President, related to the motions at bar now. The question presented to the body is related to an ongoing impeachment case, which is within the jurisdiction of the impeachment court. Should we not first have the newly elected senators take their oaths as senator judges and convene as an impeachment court? I note, Mr. President, that the Supreme Court decision is not yet final. As colleagues have mentioned, a motion for reconsideration has been filed by the House of Representatives, and the court itself, the Supreme Court, has given 10 days for the Vice President to comment. So yung point of inquiry ko nga po, Mr. President, hindi po ba dapat pasumpain na muna ng presiding officer with us convened as an impeachment court, yung mga bagong halal na senador para makapag-convene po tayo bilang impeachment court at i-treat yung mga motions at bar. Salamat po, Mr. President.
Noted and entered into the records. What is the pleasure of the Honorable
Just a very quick intervention. Very quick, Mr. President.
Pangilinan?
Permission of
Yes,
our-
you may proceed, sir.
Yes, Mr. President, and we place this on record after reading the ruling, the decision of the Supreme Court. Mr. President, the Supreme Court referred to the Senate impeachment court repeatedly. And therefore, it is the Senate impeachment court that was also impleaded. It is the Senate impeachment court that may, if it opts to, file a motion for reconsideration. And therefore, this motion to dismiss, we believe, should be forwarded to or tackled by the Senate as an impeachment court.
Your Honor, just on that point, the parties mentioned in the case is not the Senate impeachment court, but the Senate. And the dispository section of the decision makes mention also of the Senate. If I may quote, consequently, the Senate did not acquire jurisdiction to constitute itself as an impeachment court. That's the decision of the court in Duterte v. HOR.
Manifestations
The
of,
mic, please.
we will go back to the earlier manifestations of the minority leader. Yes, the Supreme Court ruled that we have no jurisdiction. Yet, the decision is flawed in terms of the facts on procedure, the one-year bar, and on due process. This is at least, of course, our assertion. And therefore, should we not wait for a motion for reconsideration to be resolved before we proceed and vote on the matter that has removed from the impeachment court jurisdiction? Should we not at least assert the power and the prerogative under the Constitution of the Senate Impeachment Court in terms of the exclusive jurisdiction, number one, and the sole power to try and decide?
That is what we will be deciding and voting upon this afternoon, Your Honor.
Thank you, Mr.
Senator
President.
Cayetano is
Yes,
recognized.
please.
Thank you, Mr. President. The distinguished gentleman, Senator Marcoleta from Tarlac and Senador ng buong bansa. Sir President, initially I wanted to speak pagbotohan na po. But very interesting po yung question na bringing up ni Senator Lacson. But aside from that, Mr. President, masyadong mabigat yung crossroads na hinaharap ng ating bansa. And remember, assuming we do nothing today, I am 101% sure that on February 6, 2026, an impeachment case will be filed against the Vice President. Maybe against other impeachable officers too. So I think it is very important that mahimay natin yung desisyon, yung sentimento ng institusyon na to, mailabas hindi lang sa social media at sa traditional media ang mga puntong nagsasaliwa, meaning pong parang hindi nag-uusap eh. So at least here we disagree, but whether we listen to the minority leader or to Senator Marcoleta, we agree to listen to each other and to examine each other's points. So I just like a few minutes on some very important matters. Let me start by the accusation that because of this decision, masyado nang mahirap at wala nang mai-impeach. So may I ask Senator Marcoleta if he would give me the honor of asking him a few questions and allowing me to interpolate on 2 or 3 topics. The first one is whether or not naging imposible na mag-impeach under this decision.
The gentleman may proceed if Senator Marcoleta will so allow it.
Yes, Mr. President.
Mr. President, sabi po nung iba, imposible na daw mag-impeach ngayon dahil sa desisyon. I see the decision before you. I approached you last week. You've been studying it. I see your radio program. Mukhang 10 beses mo na nabasa yung desisyon at apparently, Mr. Senator, you also listen to criticism. So kung ano rin yung sinasabi ng iba, pinapakinggan mo rin. In your view, may I take note first, Mr. President, that I am glad that the Senator made a distinction na he is for the rights of everyone. He was adopted by PDP and ran with a particular party, but he is not a member of the Duterte bloc. Am I correct there?
Technically speaking, Mr. President, I am not a member of the PDP, but I admit that I was adopted and I ran in unity with some of the parties of the PDP candidates at the
The
time.
point I'm going at is like, I was a cabinet member in the Duterte administration, but I have not talked to the Vice President. I ran as an independent in 2022, so I speak now as a senator and not as a partisan. I assume the same, Your Honor.
Yes,
that
Mr.
you're
President.
giving your own personal opinion as Senator Marcoleta, not as a partisan. Of course, I assume that for everyone here, no? Regardless of our position. So, Mr. Senator, sa iyong paghimay ng desisyon, sa tingin mo ba imposible na ngayon mag-impeach ng isang impeachable officer?
Hindi po, Mr. President.
So, naging napakahirap ba mag-impeach ng isang officer?
Hindi ko po alam kung bakit mahirap po sa kanila, Mr. President. Ang importante lang po, ilagay lang po sa tamang proseso. Napakasimple po kasi nung kanilang mga tuntunin, iniisip ko, sundin lang yung mga tuntunin. Ang problema po, isa man sa tuntunin, wala pong sinunod. Kaya po humirap ng humirap para sa kanila.
So, Mr. President, I'm glad you mentioned tamang proseso. I think the way the Supreme Court said it in page 95 of the decision, there is a right way to do the right thing at the right time. The problem, Mr. President, is sinasabi po nung iba, may decision na sa former decisions, meron ng definition ng initiation, and many of us here were not mere spectators there. I mean, Senator Soto, I think, was in the impeachment court, di ba, of Senator Estrada, Senator Loren too. Senator Kiko was still on the, we were together kay Senator Corona. Senator Cheese and I and Senator Mix were in the House during the prayer 1/3 to the Senate articles of impeachment, di ba? So, hindi po tayo stranger sa mga pangyayaring ito. Ang punto ko, Mr. President, Senator Marcoleta, kung hindi nagsabi ang Supreme Court ng specific na dapat sundin, pwede kong ma-interpret na baka naman masyadong mahirap. Baka naman kahit anong i-file kung gustong protektahan, hindi na siya ma-impeach. Paano na yung accountability? But is it true, Mr. President, that on page 93 of the decision, the Supreme Court actually narrated what has to be done for a valid impeachment complaint?
Yes, Mr. President.
Allow me to read. 1, the draft article of impeachment or resolution should be accompanied by evidence when made available to members of the House, especially those who are considering its endorsement. 2, the evidence should be sufficient to prove the charges in the articles of impeachment. 3, the draft articles of impeachment and their accompanying evidence should be made available to all members of the House of Representatives, not only to those who are being considered to endorse. Impeachment is an act of the entire House, which requires a qualified minority of only 1/3 of its members to be transmitted to the Senate. However, the House of Representatives is a deliberative assembly where each member should be allowed to represent the views of their constituents. Let me stop there first. Mr. President, may problema ba yung number 1? Na yung articles of impeachment kailangan may ebidensya?
Wala pong problema doon, Mr. President.
Hindi ba ho baliktad? Kung walang ebidensya, may problema.
Tama po.
Kasi kung walang ebidensya, ano yon? Tapon mo sa Senate, bahala na si Batman. So, precisely tama ang Supreme Court that even if 1/3 endorse or file, dapat may ebidensya na. Let me go to the second part. The evidence should be sufficient to prove the charges in the article of impeachment. Mr. President, tama po ba na iba po yung sufficiency at iba din po yung quality or yung burden of proof? Diba?
Opo.
So halimbawa po, sa piskalya, hindi po kailangan sa piskalya beyond reasonable doubt.
Probable.
Kailangan lang that there is probable cause that a crime was committed and there is probable cause that the accused committed that crime.
Yes, Mr. President.
So in the same manner, hindi sinasabi dito sa 2 na kailangan mo ipresenta sa mga congressman lahat ng testimony, lahat ng ebidensya. Ang kailangan lang, if you assume the evidence to be true, it will be enough to convict.
Tama po.
Because if not, then sayang lang ang oras natin sa Senate. Kung may articles of impeachment ka, walang ebidensya or may ebidensya pero yung ebidensya is not sufficient to prove the charges, either the Senate will be a kangaroo court and convict without evidence or we will be wasting our time. So wala rin problema sa number 2, Mr. President.
Wala po, Mr. President.
Number 3, ang sinasabi lang ng number 3, kahit na pumirma yung 1/3, kailangan ipakita pa rin sa lahat ng Kongreso. Isa po sa hinanakit po yun nung bata ako dahil ako po'y payat nun at hindi katangkaran. Parati akong saling pusa sa basketball, baseball, volleyball dahil hindi po ako ganong kagaling sa sports. Sa Congress ba, hindi ba tamang rule to? Na kahit wala ka sa majority, kahit wala ka sa qualified minority, kapag ka may impeachment, merely being elected as a representative of the district or of the party list, dapat ipakita man lang sa iyo yung articles of impeachment at saka yung ebidensya.
Tama po kayo, wala man lang po akong nakita sapagkat ako po hindi isinali sa pakakitaan ng...
So naiintindihan niyo po kung paano maging saling
Hindi ko nga
pusa.
po alam na meron na po pala, hindi man lang kami binigyan eh. Kaya nung tinanong ko po yung aking mga kasama, kayo pala binigyan, bigyan nyo nga ako ng kopya para mabasa ko. Wala rin kami, paano nyo pinirmahan? O hindi naman namin binasa ng pinirmahan na, basta meron lang binigay ng mga signature pages. Doon lang kami pumirma. So
Well,
hindi nyo nabasa, hindi.
God and the world has a way of correcting itself because now I have the privilege of serving the people here, not as a salimpusa, and definitely, Your Honor, as chairman of the Senate Blue Ribbon Committee, is not a salimpusa here in the Senate. In fact, you are an esteemed neophyte with a very powerful committee. So, again, number 3 is just a simple walang salimpusa rule, which is very good. Number 4, respondent have the opportunity to be heard on the draft articles of impeachment. Hindi ko na po babasahin dahil mahaba, pero basically ang sabi ng Supreme Court dito, hindi naman kailangan pumunta doon ang Vice President. Pwedeng through pleadings. Meron po bang masama dito, Mr. President, na kapag may na-impeach, bigyan man lang siya ng kopya at pasagutin muna siya sa House bago siya pasagutin sa Senate? May masama po ba dito?
Wala pong masama, Mr. President. Ang totoo nga po, sinasabi nga na dapat i-repair po lahat ng impeachment complaints kahit na yung pinirmahan ng 1/3 o higit pa, i-repair sa Committee on Justice. Yun po ang paraan siguro para magkaroon man lang ng pagkakataon ng Vice President, kahit na by pleadings lang, makasagot siya.
Yeah.
Pero hindi nga po ibinigay.
Before I go to number 5, just because I like your answer, Mr. President, one thing that guides me, no? So I've in coming to my decision with this, I follow 2 books. One, the Bible, which is of course a covenant between God and people, tayo, and the Constitution, which is a covenant among the Filipino people and the government, no? Alam mo, both books talk about due process. Ang Panginoon, nung kinain ni Adam at Eve yung prohibited fruit, nagtanong muna siya, ba't kayo nagtatago? Hindi nag-accuse, nagtanong muna, pero alam na ng Diyos. So ang ibig lang sabihin ng due process, sabi ng desisyon ng Supreme Court, magtanong ka muna bago ka humusga. So Mr. President, I was thinking, what if naging masyadong emotional yung eleksyon ng huli? And one-third of members of Congress ay naging anti-administration. At ang kinahaharap natin ngayon ay isang impeachment labang kay President Marcos. At pag siya'y na-impeach, magiging presidente si Vice President Sara. I wonder if all of us in this room and out of this room will still have the same paninindigan. I hope I will. I'm not judging. I am just saying, Mr. President, what helps me is those 2 books, but also to put myself in the opposite side, to put myself in that position. What if, so I'm looking, I see my good friend, former Senate President Subiri, shaking his head. So, natanaw ko tuloy si Senator Kiko. What if Vice President Lenny and Senator Kiko won in 2022? And what if ang ini-impeach ngayon ay si Senator Kiko? I hope yung decision ko to support this decision would be the same.
Tama
Because
po,
the Supreme-
dapat walang pagkakaiba.
Wala saan pagkakaiba. So number 5, a reasonable period of time determined on the basis of complexity of charges must be given to all members of Congress. Kasi lumalabas po, yes, tama si Senator Soto, ibang mode yung 1/3. Pero lumalabas po mismo sa pleadings, mismo sa sinabi ng House of Representatives, wala pang 3 oras. Yung
Wala po.
ibinigay sa mahigit 200 na pumirma, samantalang ang complaint is a few hundred pages. Tama po ba?
Mahaba pong pahina lahat yung sinabi sa akin, Mr. President, at hindi po nila nakayang basahin sapagkat wala nga silang kopya. Humihingi po sila ng kopya bago pumirma, ngunit wala pong ibinigay. Yun po yung sinabi sa akin ng mga ilan sa aking mga kasamahan doon.
Yung number 6 po, Mr. President, madali kasi kailangan yung impeachable act is an act done while they were in their present office. So wala naman pong problema dyan. Meaning, kung may nagawa si Senator Cruz nung konsyal pa siya, pero ngayon Vice President na siya, hindi naman siya pwedeng impeach base sa ginawa niya nung konsyal siya.
Tama po.
So madali po yon. Number 7, at the very least to accord the opportunity to be heard under the requirement of due process in the procedure under Article 11, Section 3, Paragraph 4, after the draft articles of impeachment and required proof arrived at. Letter A, the House of Representatives should provide a copy of the draft articles and its accompanying evidence to the respondent and give her an opportunity to respond within a reasonable period. May problema po ba dito?
Wala po.
Kapag ka ganito kabigat, natatanggalin mo ang isang impeachable officers, tama po ba yung surprise?
Hindi po.
Parang, eto yung wag mo nang tignan, 1/3 naman kami, sa Senado ka na, sa Senado ka na mag-reply. Letter B simply states that all members, again, it's the walang saling pusa. So, Mr. President, in other words, it is not true that it is now too difficult. Sundin lang yung page 93, 94. Whether it's February 6 for the Vice President or if anyone wants to file an impeachment against anyone, magagawa to at any time.
Tama po, Mr. President.
Let me reverse my question, Mr. President. Dapat ba maging madali mag-impeach ng isang officer? I'm asking, of course, your opinion that I value, Mr. President.
Depende po sa ini-impeach na opisyal. Pero kinakailangan po hindi dapat magmadali. Kaya dalawa po kasing bagay yun eh. Kailangan po siyang mapagbigyan ng due process niya at gaano man po karami yung ebidensyang inaharap sa kanya. Bigyan natin siya ng pagkakataong makasagot. So maaari pong mahirapan ng konti, tumagal ng konti. Ngunit kailangan po natin ibigay lahat ng proseso sa ini-impeach at sa mga nag-i-impeach.
I value your answer on due process, Mr. President, and that's my second point. But if you would just also accept, or maybe I can put on record, I'm of the personal view, hindi dapat maging madali mag-impeach ng isang impeachable officer. Bakit po? Unang-una, iilan lang po sila sa ating bansa. Ombudsman, member of constitutional commissions, President, Vice President, Supreme Court. Hindi dapat madali dahil it's an extraordinary remedy in extraordinary circumstance not to penalize them, but para protektahan ng ating bansa at para nga po alisin sila sa equation if they will damage our country. So the difference po with this impeachment sa iba, at least the impeachment of President Estrada, President Arroyo, and again, may I be sensitive especially to my friends here who are of that administration, was with us, against us, or like Senator Jingo and Senator JV. Yung feeling kasi doon is that if there was another day na hindi na impeach, magagamit yung opisina na yon kasi presidente pinag-uusapan. Ganon din sa Chief Justice, na habang nandun ka, ma-impluensyan mo yung korte. Pero pag pinag-uusapan mo Vice President ngayon, wala naman siyang hawak na departamento, wala siyang hawak na agency, wala namang police, militar, NBI, Coast Guard, whatever under sa kanya. Yes, we should hold her accountable kung may ginawang mali. Dapat i-impeach pag may ginawang mali. Pero it's not true that today and tomorrow matters that much. Because wala naman siyang opisina na magagamit not only to cover her tracks or to damage the country. Diba? In fact, I doubt kung walang perpetual disqualification yan, baka iba ang suma natin ngayon. But I don't want to go to the political aspect. The point I want to make, Mr. President, is para tayong nag-Goldilocks, pag gusto natin yung i-impeach natin, so nung time na yon na gustong impeach si President Erap, padaliin natin. At kung hindi, walk out tayo. Kung kakampi mo si GMA, pahirapan natin. Kung kakampi mo si Duterte, pahirapan natin. Diba? So, in that point, I see why the Supreme Court, they made a statement Nag-statement sila about history. Sabi ng Supreme Court, ito po, sa page 94, we understand our history. We have learned that in the past, momentary desires to do what is convenient and concede means to ends have inadvertently created precedents that weaken the succor of law for those who dissent, or those that are society's margins, or those who have fallen out of grace from the powers that be. We have learned that the clash of political interests in the past, often disguised by noble intentions, have obscured the need to address the real problems of corruption, inequality, poverty, and disempowerment faced by our people. Kung ito lang po ang sinabi nila, Mr. President, sasabihin kong hindi ba namumulitika yung korte? But sinabi nila to after page 93 na iniisa-isa nila paano mo i-impeach eh. So parang ang tinuruan na ang Senado at saka House